All right, guys, welcome to the show. As you can tell, I'm still on vacation, but nonetheless, I'm here and we got a full show. So a lot of stuff to talk about. There has been some movement in terms of Biden potentially dropping out. I'd put the odds at 60-40. 60 he stays, 40 he leaves, but maybe we're getting closer to 50-50 now, based off all of the pressure that's being brought now by many rank and file Democrats. So we'll talk about that in just a second. We're going to talk more about the Supreme Court decision. Just how bad is it? I read everything I could get my hands on about this Supreme Court decision, and I want to break it down for you in even more detail and what we can do about what's basically a rogue court. Then we'll talk about RFK allegedly eating a barbecued dog, some sexual assault allegations against him as well. So he's not having a very good week, to say the least. I can't imagine looking at a situation where Biden's brain implodes and he is shown as a cadaver to the world. You would think that could be a good week for RFK, but no, it's not. He totally shit the bed yet again. And by the way, his response when he's asked about the sexual assault allegations, probably the single worst response I've ever seen from somebody in the midst of a scandal. All right, so we'll talk about that and more. Let's get it started with this. So I want to play this video for you. This is Justice Sonia Sotomayor questioning Trump's lawyer about just how extensive the presidential immunity is, in his opinion. And this is shocking. This is the actual argument they were making in front of the court. Listen to this.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it, like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold.
It says we won't hold you responsible. The video just froze on us.
How could that be?
So look, if his argument is to be taken at face value, and if this becomes the law of the land, we no longer have a president. We have a king. We have an emperor. We have somebody above the law. And this is just like remember that famous Richard Nixon moment? If the president does it, it's not illegal. That would actually be the law in this country. That there is no law vis-a-vis the president. That's effectively what he's arguing for. Now, by the way, John Roberts kind of agrees with that. John Roberts basically says all official acts are protected. But he also says anything on the, quote, outer perimeter of official acts are protected as well. So anything that you could remotely make even a stretch of an argument, oh, I did this because I'm president and because it's an official act, he goes, good enough. So to John Roberts, the unofficial acts are not protected. But what constitutes an unofficial act is a very tiny sliver of stuff. If Trump orders one of his underlings, one of his staffers, to commit a crime, Robert says, hey, your own staffer, your underling, it is your job to give them orders. So the fact that you gave them some semblance of orders, even though they're illegal, that doesn't matter because this is still the outer perimeter of your presidential duties and under your presidential authority. So absolutely terrifying. Now, by the way, that's what Robert says. You have even Amy Coney Barrett, a very conservative judge. She does not say that. She says, yes, official acts are protected, but what constitutes an official act is not nearly as expansive as what Roberts seems to think it is. So there's disagreement even with the majority, the 6 votes that ended up winning this case, which, by the way, means that it's going to be largely ambiguous moving forward. You're still going to have the Jack Smith case go forward, although on a slower timeline. They're still going to try to get him on certain crimes. And then my guess is it will probably get back to the Supreme Court again. And they'll have to rule more directly and more specifically on the facts of this case, as opposed to just the broader topic of does he have immunity or doesn't he have immunity. Okay, now I want to play you this. Again, now specifically when it comes to the fraudulent elector slate, not my words, theirs. the fake elector slates. This is what Trump's lawyer argues. Listen to this.
You have conceded here the last time that you and I spoke in April, and John Sauer, who was arguing this before the Supreme Court, that some of what's alleged would be considered a private act. So that would mean that at least part of this case from Jack Smith would go to court based on what you have said before, right?
We've admitted consistently that there are acts alleged in the indictment that would constitute private conduct. But we believe that if the official conduct, the immune acts in the indictment are stripped away, that Jack Smith doesn't have a case, that this case should be dismissed on that basis. I don't think there's sufficient private conduct here to support the indictment, to support the ongoing prosecution. And that's what we're going to be litigating in front of the district court now.
Even just the false slates of electors, you don't think that would constitute enough for a trial?
Well, we would say alternate slates of electors. And as we argued before the Supreme Court, alternate slates of electors have been a method used by previous presidents, most notably Ulysses S. Grant, to ensure the integrity of prior elections. So we believe the assembly of those alternate slates of electors was an official act of the presidency. That's what we argued before the Supreme Court. The Supreme Court has reserved that issue for determination by the district court. And we'll see how arguments fall in front of the district court.
Yeah, we've walked through those historical references here before. None of them compare to what we saw in 20 with the fake slates of electors. But Will Scharf, great to have your reaction to this. Thank you for joining us tonight.
I would disagree with that, Caitlin, but great to be with you. Thank you.
So the difference is with Trump's fake slate of electors, fraudulent slate of electors, this happened after the respective states had already certified and verified the election to say, hey, Joe Biden won this state. With the other historical examples, they were genuinely alternate slates of electors, and they were put in place before the actual official certification of the election. So there is a massive, massive difference there. Now, again, it's true that the lower court is going to determine whether or not this is, like private conduct or official presidential conduct. So is it an official or an unofficial act? And whatever they decide, again, is not going to be the final word, because this is probably going to get back to the Supreme Court. And it appears like right now it's going to be a close decision. It's not going to be 6-3, because I think Barrett is going to flip on that. She's going to be more with the liberal justices. And then, you need to pick off more, right? So it'll be interesting to see, but Roberts has a very hard line view of this. Roberts' view, again, is that official acts are protected, and even acts that are on the outer perimeter of that which is official are protected. So, and he says you can't even look into their motive. So, okay, well, if you can't look into their motive, how can you determine whether it's an official or unofficial act? It seems like he's trying to carve out a lane to protect Trump for everything Trump does, right? And I don't know. I think the lower court, it's still possible we get a guilty conviction in the Jack Smith case on some of this stuff, but it's going to eventually get back to the Supreme Court. And if these arguments hold up that the Trump lawyer's making, I mean, I don't want to be hyperbolic about it, but I think the resistance liberals are 100% correct. This truly is the end of democracy, the end of having a president who is subject to laws. This is now, total emperor king type stuff. And then, by the way, you got to ask the question, what will happen from here, right? Like, if Trump gets another 4 years, he knows now there's no brakes in the car. He knows he can do whatever he wants, and he has broad leeway. As long as he says, I'm doing it because I'm president, and this is some presidential stuff to do, he can theoretically get away with it, right? And Biden came out and did a press conference and said, don't worry, I will respect the limits of my power. And it's like, well, maybe that's the problem, is that they're granting this, broad unitary executive theory of power. They're making that the law. And you're like, I will proceed to not use it. So you have the Republicans aggressively moving the country in a far right direction. And you have the Democrats just being bland centrists and keeping the status quo chugging along. Okay, so this article here from SCOTUS blog, I'm going to highly recommend all of you read it. The title is Justices Rule Trump Has Some Immunity from Prosecution. Now, if you really get into the weeds of the case, there are some things that even Justice Roberts says, hey, this is both unofficial and potentially illegal, right? And I think the example that he uses is the pressure that's put on the Arizona state government, the Arizona Republicans. The Trump team was putting pressure on them to basically throw out the results and certify him. And according to Justice Roberts, he says, look, Trump, as part of his presidential powers, he has zero say in the workings of the state government of Arizona. So in other words, Roberts says there's not even really a stretch of an argument that what Trump is doing here is part of his official duties. Therefore, that's an example of something that, is both unofficial and potentially criminal, and that aspect of the Jack Smith case can move forward. But he also says you can't use evidence of official acts to try to make the case against the unofficial acts. And again, I don't see how that's possible then to build the case if you're basically handcuffing Jack Smith and the prosecution and saying you can't bring all the evidence and lay it out there. Anything that's remotely official, you have to leave off the table. You can't even look into motive. You can only use the unofficial acts. And again, the stuff Roberts says are official acts, it's an incredibly narrow sliver of what makes up this case. So it just got way more difficult. So go read this whole article because you'll get a sense that Roberts is wrong. Roberts is crazy. Roberts has a very wide-ranging view of what constitutes an official action from a president. But even Roberts says, hey, there's some tiny slivers here around the edges that are potentially both unofficial and illegal, and that part can proceed. But again, you see even Amy Coney Barrett, who sided with the majority here, she basically was like, Roberts is crazy. And apparently her and Sonia Sotomayor, they didn't use respectfully in their dissents, which is like breaking precedent. In other words, what they're saying is, not only are you wrong, you're like comically wrong and embarrassingly wrong. And you really are trying to change the nature of this country and make it so we have a king or an emperor. Because again, even Amy Coney Barrett says, yes, official acts are protected, but basically like, let's stop pretending that the stuff that Trump was doing in this instance is an official act. It's not even close to an official act. So here, I'll point that out for you here. Larry Lessig pointed this out. This is the money quote for the whole Trump v. United States case. Justice Barrett has it exactly right and shows why the court and maybe the special counsel is making this way too hard. The sole question should be whether acts relating to running for president are core executive functions or not. Obviously, they are not. The president has no role in the selection of the president, period. So Amy Coney Barrett directly says, look at the fake elector slates. This is private conduct. This has nothing to do with being president, because being president doesn't constitute any power in terms of, picking a president. Like campaigning for president is not the same as being president, right? It's not the same thing. It's not remotely the same thing, because you could run for president, but you're not president. It happens all the time. People run for president, but they're not president. So how could you say this part of the process, which is a running for president thing, right? How does that stuff fall under official acts? And Barrett is like, it doesn't fall under official acts. Who are we kidding here? So this is her being like, sort of like, screw you to Roberts, who's really overreaching on this one. So look, the fact of the matter is, the decision from the Supreme Court was horrible, but this is still largely unsettled because aspects of the Jack Smith case are going to continue. It's very possible that for the remaining things, they get a guilty verdict. Then it's very possible it goes back to the Supreme Court and we're right back at square one. And the Supreme Court is going to have to rule more directly and specifically on whether or not Trump trying to overthrow the election was a crime. And again, it looks like Roberts is going to be on the wrong side. Clarence Thomas is going to be on the wrong side. Probably Gorsuch and Kavanaugh probably on the wrong side. But Barrett's gone. And I don't know. It'll be close. But the other thing is, if this becomes standard operating procedure now, if this becomes precedent, well, then again, okay, be careful what you wish for. I've seen articles, even in the Washington Examiner, a right-wing outlet, where they're like, this is insanity, and I'm saying that from a conservative perspective. Because as a conservative, do you want a President AOC having full immunity, not only for official acts, but the outer perimeter of official acts, and maybe even unofficial acts that she says are official, but they're unofficial? Do you want her having, total immunity in every way, shape, and form? Would you want President, I don't know, J.B. Pritzker or Gretchen Whitmer or Gavin Newsom or whatever? Do you want them to have total immunity? So in other words, stop being so short-sighted is what a lot of conservative writers are saying in the Washington Examiner. Because, yeah, you notch this as a win for Trump, but Trump's only going to be around so much longer, right? And do you really want to give a president this much power? The whole idea of conservatism, a traditional view of conservatism, is smaller government. This is the biggest government imaginable, with the president above the law. So really crazy stuff here. Let's talk about solutions, right? Let's talk about solutions. Because the fact of the matter is, this is a rogue court. That's what it is. It's a rogue Supreme Court. So what can we do about that? Well, now, listen to my boy here, Tom Hartman. He's going to break down for us ways that we can fight back, which are real, which are tangible, which would effectively make the court put them back in their proper role. Here we go.
How do we fix that? And how do we fix, or for that matter, get control of an out-of-control Supreme Court? It's a really vital question. Check it out. Leave your comments, ding the bell, share this with your friends, and subscribe to our channel. So what do we do with a Supreme Court that is out of control? Franklin Roosevelt faced this. Actually, the country faced the possibility of this after Lincoln was assassinated. In fact, let's just go back. One of the ways, there's two things in the Constitution, Article 3, Section 2, about what you can do with the court. One is you can regulate it. The other is you can create exceptions to what the Supreme Court may do. So let's take these one at a time. The regulated part. Typically the way Congress regulates the Supreme Court is by determining how many members it has. Congress can also determine when it meets, where it meets, what its budget is, and can even prescribe rules for it, like ethics rules, which I think would be a really, really good idea. Forcing passing a law that says the Supreme Court has to comply with the Federal Code of Ethics for federal judges. The Supreme Court is exempt from the Federal Code of Ethics, which is why Thomas and Scalia were able to go to all these Koch brothers events and get paid big speaking fees and get feted at five-star resorts like the one, the hunting retreat where Scalia died.
Which, by the way, that's step one. Code of ethics for the Supreme Court. That's a layup. That's a no-brainer. This is how we have a rogue court. This is how we have a court that represents just the moneyed interests. Just the billionaires and the robber barons and the corporations and the people that wine and dine them and give them luxury gifts. This is how we got here. Step one, layup, obviously. Code of ethics for the Supreme Court, and strictly enforce it at penalty of losing their seat. Or maybe even jail time if they're as corrupt as they indeed seem to be.
When Lincoln was assassinated, Andrew Johnson, a slaveholder and Southerner, became president. Lincoln's biggest mistake, putting this guy on the ticket with him for his second term. And Congress, which at the time there were 10 members of the Supreme Court, and Congress was so horrified by the possibility that Andrew Johnson might appoint somebody to the Supreme Court that they immediately met and passed a law reducing the number of members of the court to 6. So that up to 4 people could die before Andrew Johnson would have a chance to put somebody on the court. Andrew Johnson lost the election in 1868. Ulysses Grant became president. In 1869, when Congress met, they got together and they said, okay, that's it. We're going to take the court back up to 9 people, which is where it is right now. So they nakedly, for purely political purposes, changed the number of members of the Supreme Court.
Think about that. This is back in the day when the opposition party would give opposition. When they would say, hey, you guys are really fucking shit up. How about we fix it? How about we do something? It's not like that anymore. It's not what the Democrats do. What did Biden do? He called a press conference and said, I dissent. And then he walked out. No plan of action, no tangible solutions, no policies, no threats to the court to fall in line. He just said, I dissent. Look at what they did back in the day. Oh, let's just handcuff this guy. He can't get any picks on the court. And then, we'll clean this mess up.
Then in 1937, from 33 to 36, the first term of Franklin Roosevelt's administration, Congress kept passing great laws, child labor laws, minimum wage laws, right to unionize law, just a whole series of really great pieces of legislation. And the Supreme Court was knocking down almost every single one of them.
The Lochner era of the court. That's when they were slapping this stuff down. They were judicial extremists and judicial supremacists, just like we have right now. And you're about to hear what FDR did to deal with them.
So he wins re-election in 36. He gets reinaugurated in 37. And the Social Security Act is coming before the Supreme Court. And the word is that they're going to strike it down as unconstitutional. Just like they struck down child labor laws as unconstitutional. Just like they struck down the minimum wage law as unconstitutional. And so Franklin Roosevelt says, I'm going to propose legislation that will say that all of the justices on the court who are over 70 years old, collectively, they'll still be on the court. The Constitution doesn't say you can kick them off the court. Federal judges have their jobs for life. They'll still be on the court, but they will have one vote among them. They will be justices emeritus if they're over 70. And there were 5 of them on the court at the time who were over 70. And then I will replace the missing 4 votes by adding 4 new members to the court. It was called a court packing scheme. If you read the Wikipedias and things of today, everybody says, it's so unpopular. FDR took so much flack for that. In actual point of fact, if you read the histories, as I quote my book, that were written in the 1940s, 50s, and early 60s by people who were actually there, it was very popular. There was a very good chance that Franklin Roosevelt would have gotten this through Congress. It had a lot of public support. And the only reason he didn't need to go forward was because Justice Owens and Justice Roberts, in response to public pressure, frankly, changed their votes. They started voting with Franklin Roosevelt. And that put an end to the court packing scheme. And then FDR, replaced, I believe, every single person on the court. Maybe there was one he didn't, but I think he replaced the entire court over the course of his 4 terms in office. And so you had a relatively moderate court going into the Eisenhower administration and the Kennedy administration as a result of that. And then, Nixon committed treason and became president and started packing the court. So one thing that we could do is actually change the makeup of the court. And Elizabeth Warren has suggested this. Say, okay, we're going to go to 13 justices now, and I'm going to be putting some on. Or we're going to stagger when they go on and when they go off, and then we'll move them off the Supreme Court back into the federal bench, which is okay with the Constitution. And so every president will get to appoint 1 or 2 or something like that. I mean, there's these plans to reorganize the court. That's one possibility. The other is something that a young lawyer was given the job by Ronald Reagan to figure out back in the early 1980s. Reagan was swept into power by a Supreme Court decision in 1976, Buckley, and then in 1978, First National Bank. These 2 decisions opened the floodgates to billionaire and corporate money for federal office. And so in 1979 and 1980, just gobs of cash flowed into the Republican Party and made Ronald Reagan president, in addition to cutting a deal with Iran to hold the hostages and make Jimmy Carter look weak. And, as that money came in, Reagan, a couple of Reagan's campaign promises were that he was going to reverse Brown versus Board of Education, the 1954 decision that said segregation is illegal. He was going to reverse that. And he was going to reverse Roe v. Wade, the 1973 decision that gave women the right to have an abortion. Now, in some states, women already had that right. In other states, they didn't. And, there's a whole kind of thing here. But he said, we're going to reverse these 2 decisions. So he hired this young lawyer, brought him into the Justice Department, said, here's your desk, here's your office. You got a year to figure this thing out. This lawyer did a deep dive into the founders, into Hamilton's writings, Jefferson's writings, the Madison's notes on the Constitutional Convention, the history of the Supreme Court, the history of judicial review throughout the years, and ended up writing a 29-page memo that was like a small nuclear bomb going off in the Reagan administration. And what this young lawyer said was, according to the Constitution, Congress can create exceptions to what the Supreme Court may do, what they may rule on. So all we have to do is have Congress pass a law saying that segregation of schools is, in fact, legal, and states may, in fact, pass laws forbidding abortion, effectively overturning Brown and Roe. And then the last sentence of that law has to be something to the effect of, and this law may not be reviewed by the Supreme Court. He said, just write that into the law. It has been done in states over the years. It's called jurisdiction stripping or court stripping. It has, and it's actually been done in some federal laws, have been written with that clause in them, but they were never controversial things. Tom Daschle, when he was Senate Majority Leader, got language similar to this in one of the farm bills, according to Phyllis Schlafly. But, it was never litigated. Now, the decision that the Reagan administration came down to after this young lawyer came up with this whole long memo and said, just do this, the decision that they made was that, doing such a thing would be a political bomb going off. And it would set up a battle between the legislative branch, which the Republicans controlled then, and the executive branch as their ally, and on one hand, and on the Supreme Court on the other. I mean, the Supreme Court could say, wait a minute, we're going to rule that your law is unconstitutional. Your law saying that we don't have the power to rule on something. And they felt like they didn't have a large enough majority in the House and Senate to take on the Supreme Court like that. And so it never went anywhere. It just sat in a drawer until I found it last year. That young lawyer, by the way, that Reagan hired, who came up with this idea about here's how you neuter the Supreme Court, his name was John Roberts.
Do you understand what you just learned? Do you understand what you just learned? You just learned that court stripping or jurisdiction stripping, which is taking power away from the Supreme Court, is perfectly constitutional. In fact, it's in the Constitution. And John Roberts was the biggest proponent of it back when he was working under the Reagan administration, and the court was more left-leaning, and they wanted to stop them from holding up a conservative agenda. In fact, here, I got it for you right here. Article 3, Section 2. Here we go. Listen to this. Right here. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. In other words, if Congress says the Supreme Court doesn't get to rule on criminal matters involving the president, you can make a law of that. and they can't do shit about it. That's the end of the conversation. Congress can regulate the Supreme Court, and this is something that they haven't done. Just out of habit. But they can do it. In fact, you can even go a step further. We're going to decide all of the cases that you guys hear. We'll determine which ones you're going to hear and which ones you're not going to hear. Because Congress regulates the Supreme Court with such exceptions and under such regulations as Congress shall make. Hey, we're going to decide now on, you're only hearing, disputes over things not relative to constitutional law. Effectively, you can reverse Marbury versus Madison casually by using the court stripping provision of the Constitution, Article 3, Section 2. So, let's review. He brought up a number of ways that you get the court to fall in line, that you fight back against the judicial supremacists, which is what they are. They're authoritarian. They've massively overreached. So what do? You can do term limits for the Supreme Court. You can pack the court. You could have some sort of a revolving court system. This is ways to restructure the court. And you can do jurisdiction stripping or court stripping. You can do that. And historically, when there's been massive overreaches of the Supreme Court, they've been slapped back into line. It's time to bring that back because we can't take this anymore. They are one of the most responsible parties to the downfall and destruction of this country, and the right corruption and the authoritarianism and the oligarchy and the kleptocracy. The time to act is now. It's not time for speeches.
Hey y'all, do me a favor and like and subscribe. It helps out big time in the algorithm. Click the bell as well for notifications when videos drop, and watch that video on screen right now. You know you want to.